Good evening, everybody, and welcome to our webinar this evening. So on the chat, I have added the title of our webinar and the names of our speakers and my own name. I've also added in the chat the link to some of the documents that our speakers will be speaking to. So a very warm welcome to it's a student webinar, and our means the SOAS Arbitration and Dispute Resolution Center. If you're not a member yet, our administrator, who is the one that makes sure the center runs at all, Hannah Imai, would add a link in the chat so that you can register and become a member of the center. For now, it is free. So the earlier you join, the better, so we don't start charging you soon. Okay. I'm going to invite our speakers to briefly introduce themselves. And the idea is so that they can try their vocal cord and be sure that their voices are clear. As you can see, they are the ones who organized, and it's only men on the panel. And because this is the SOAS Arbitration and Dispute Resolution Center, where we do not do one-gendered activities, I insisted that I am going to moderate. And so hopefully we look forward to having a very interesting discussion. So can I invite Udayvir? Do you want to quickly introduce yourself, please?
Thank you, Professor Onyema. Good evening, everyone. My name is Udayvir Ahuja, and I am a lawyer qualified in India, and I'm currently pursuing my LM in Public International Law at SOAS, and I'm also student rep of the SADRC committee.
Thank you very much, Udayvir. I noticed that some people are already putting their names in the chat, and that is really very good. So please feel very free to add your name in the chat and tell us where you're joining us from. And that is absolutely fine. And if you have comments, you can pop them in the chat, and that should be fine. We would be looking at the chat. Tawan?
Good. Hello, everyone. My name is Tawan. I'm a Master of Law student in SOAS and a member of SDRC.
Thank you very much. You can see that they're keeping it really short. So because I already threatened a little bit. Raoul.
Thank you, Professor. Good evening, everyone. My name is Raoul. I am originally from Côte d'Ivoire in West Africa, and I am a PhD student at the University of Bordeaux in France.
Thank you very much. Mark?
Good evening, everyone. Good afternoon, good morning, depending on which part of the world you're in. My name is Mark Wasunna. I'm from Kenya, currently a PhD student at SOAS University, researching on the attitude of the Kenyan courts towards enforcement and annulment of arbitral awards. I'm also a member of the SADRC, as well as a member of the Chartered Institute of Arbitrators Kenya branch, and I also serve as a graduate teaching assistant at SOAS. Thank you.
Okay, so I'm sure by now you can all tell the difference between LLM and final year PhD students, because they have so much to say. So thank you so very much, guys, for accepting our invitation to engage with this question. It's a comparative exercise that we want to do. A few weeks back, we had Louis Flannery Casey, who unpacked the reforms around the English Arbitration Act. And this is something we have studied in class. This is something that our PhD students on the panel have also engaged with. So we didn't want to just come and talk at you and tell you, oh, these are the reforms, because everybody knows what the reforms, hopefully everybody involved in arbitration knows what the reforms are. But what we wanted to do was look at it from a comparative perspective, because Mark's PhD and his research looks a lot at the uncitrol regime. So Mark will bring in the uncitual model law regime to the discussion. Raoul already told you he's doing his PhD in Bordeaux, and you can hear that he sounds very French, speaking English in French, but that's absolutely fine. We accept that at SOAS. And so Raoul would bring the perspective of the current ongoing reforms of the French, or proposals to reform the French Arbitration Act, which underpins most of Francophone Africa and Ahuja, their laws. And so Raoul will bring that into the discussions. Now, the core English Arbitration Act people on this webinar are Udayvir and Tawan. They're the ones who would lead the discussion, and then Raoul and Mark would bring a comparative view to it. So I'm going to turn to Udayvir. Udayvir, do you think that the reforms that we have seen coming out of the Law Commission as it relates to the English Arbitration Act, do you think it's been comprehensive? And is there something in particular that one of the reform topics that you would like to kick us off with?
Yeah, so in my view, it is rather comprehensive, and a majority of the recommendations have been accepted. I think the most primary ones, which is the most important, is by far the law of the seat. So as per the section 1, which is the very first one, it makes the default rule that the law of the seat which will govern the arbitration agreement unless the parties agree otherwise. Now, this is very, very important and with the background of the Enka v. Chubb, where the Supreme Court of the UK held, which is a bit of contentiously, I would say, like when there is no express or implied choice of law in the arbitration agreement, the governing law of the arbitration agreement will generally be the law selected by the parties as the law of the main contract. Now, as opposed to this new amendment has made very clear that that would not be the case. And in case of an arbitration, the seat of the arbitration itself would be the governing law if there is no implied or explicit mention of the party as to what law will govern the arbitration agreement.
So for you, do you think that that brings greater clarity to
Absolutely.
the law,
Yeah,
considering that
absolutely.
you had to read 140 pages of Enka v. Chubb? So do you think that it will make your life easier now in identifying the law that governs the arbitration agreement?
Absolutely, because I remember in the first month of my time at SOAS, I had to read the judgment. It was a very detailed judgment, very recent one, but a very confusing one at the same time. And this, on the other hand, will enhance the legal clarity by reducing even disputes over the governing law of arbitration agreement, which is the major chunk of the disputes. So I think this brings a lot more clarity, and it makes London and UK a more suited seat of arbitration for all international arbitrations going forward.
Okay, thank you very much for plugging London and the UK for us for more arbitrations. Raoul, France and most likely Paris might not be very pleased that Udayvir wants more arbitrations coming to the UK and to London. What is your view on the law applicable to the arbitration agreement as it relates to the French law?
Honestly, that point of view from the English Act is completely different from the French perspective. Because in France, it is better to rely on a substantial rule, which is based on the parties' will and the parties intend to go to arbitration. So we don't rely on any domestic rules. There is a principle according to which the arbitration agreement is automatically validated as well as parties want to go to arbitration. So we don't rely on any domestic rules. It is only the will of the parties which is most important. Because I don't understand why we can say that arbitration agreement is autonomous from the law governing the main contract, but in the meantime, that agreement is supposed to rely on the law of the seat of the arbitration. So sometimes it seems like there is a misunderstanding from the French perspective.
Okay, so do you Do you therefore think that since the French law is undergoing some form of reform at this time, do you think it will make things a little bit more certain if the French jurisdiction was to adopt maybe the UK position of, if the parties have not made a choice, a strong connecting factor will be the law of the seat, or the Singapore position, which is that, well, the law applicable to the merits would be a stronger connector, because that would help for certainty? Or would you prefer that, as the current position is, leave it to the will of the parties and the tribunal determining that point where the parties have not made a choice?
The fact is that when we look on the current situation, it seems like parties are obliged to choose a law before going in arbitration. And we all know that in international arbitration, the most important thing is to let parties conduct their proceedings. So from my perspective, it is better to base or to rely on that will from parties instead of any domestic rules, because from the French perspective, arbitration is a completely autonomous system different from national or from domestic rules. So it is not fair to rely on any domestic rules to determine if the arbitration agreement is valid or no. It is better to only rely on the parties' will or their intention to go to arbitration.
Thank you very much. So we will not push the French any more than this. If you have a view, please put it in the chat as well. I'm going to now turn to Mark. Mark, on this point, and as it relates to the model law jurisdictions, Kenya is an early model law jurisdiction from the continent of Africa. So what's your view? Is there anything in the model law on the seat?
So there's nothing expressly stated within the model law on the law applicable to the arbitration agreement, and I strongly agree with Udayvir that the new model adopted in the new 2025 English Arbitration Act is very good, because it's direct and stipulates exactly what's to happen in case of a dispute, and so it limits the chances of disputes arising in this area. And with the lack of an express provision within the model law on this law applicable to the arbitration agreement, it's allowed courts, national courts within model law jurisdictions, to come up with their own interpretations. And we can see from Hong Kong, which, according to the Queen Mary's survey in 2021, is one of the top 5 jurisdictions for arbitration, which is also a model law jurisdiction. In China Railway Hong Kong Holdings Limited versus Chongqing Holdings Company Limited, the court in that case actually adopted the stance taken by the courts in Enka v. Chubb, where the Supreme Court in Hong Kong actually held that it appears to tally with the Hong Kong law. And so as such, within a dispute on the law applicable to the arbitration agreement, they adopt exactly what was taken in Enka and Chubb. So in the absence of an express choice of law for a jurisdiction clause, the court will consider if the parties have designated a governing law through an implied choice. And then the express choice of law for the main contract will generally be implied as a governing law applicable to the jurisdictions clause, and only when the parties' intentions cannot be identified through a contractual interpretation that the court will resort to a system of law which has the closest and most real connection to the jurisdiction. So we can tell from this already, and as was the issue with Enka v. Chubb, it's not specific. It's in a sense vague, and so it leaves a lot of interpretation, and it leaves the door open for many challenges in this issue. So I would adopt what Udayvir has said, and maybe recommend that model law or UNCINTRAL within any reform of the model law consider adopting what the English have done by creating a definite step as to what is to happen when there's no clear law applicable to arbitration agreement.
Okay, great. Thank you so very much for that. And just sort of pulling all of this together and going back to one of the cases that we also had read in class, which is the Dalla v. Pakistan case, where the French courts, on the basis of, again, the autonomy of the arbitration agreement and looking at that autonomous regime, concluded that French law, being the law of the seat, governed the arbitration. So maybe the seats people seem to be winning this this war. So thank you very much for that. Tawan, I'm sure you were feeling a little bit left out of this conversation. It's because you're leading the next round of conversation. So which of the reforms is it that particularly you engaged with?
Yeah, I think to start with, I think it would be good to start with Section 39A, which is the summary award disposal. So I think it's one of the most practical and overdue reform for almost 30 years. This new provision gives the tribunal the express power to issue a summary award. It basically basically gives the power to decide a claim or defense early if it clearly has no real prospect of success. Now, this is something we have seen for a long time in the court system, but for arbitration, it's always been a gray area where the tribunal were often cautious. Even if the case were always weak, clearly weak, they felt that they have to go through the full process to avoid being challenged on the due process ground. What Section 39A does is it brings clarity. Basically, you can dispose of hopeless claims early, but only if the parties involved have notice and both sides get a chance to be heard. So from a procedural perspective, this is huge. It saves time and cutting down costs on unnecessary and discourage party from dragging things out of the unmarriageous argument. Of course, often this will be depends on how confident depends on how confident arbitrators are in applying it, the practical implementation, and there's a fine line that when you act too quickly, you're risking the appeal, and when you act too slowly, this risk reform loses its impact. So overall, I think it's really a step forward to keeping arbitration in London an efficient place.
Okay, so you sound like you agree with this reform. You're happy with this reform, even though you recognize the tension between moving too quickly and depriving the parties of the opportunity to fully present their case. When we go through a summary dismissal, but at the same time, you think that it would balance things out.
Yeah, definitely. I think it's about cost and benefit and balancing the different interests in the arbitration process.
Okay. So Raoul, let me turn to you. What's your view? Do you think that this is something that the reforms of the French law should be considering to pick up on?
Yes, of course, because as Tawan was saying, it is important in arbitration to save time and money. So if arbitrators see like it is important for them to just have a summary disposal in order to avoid parties to go further and quickly ending the proceedings, I think is a good thing. And it might be something the new French Code of Arbitration should rely on in order to make like a good framework for parties and arbitrators when they choose Paris as the seat of their arbitration.
Okay. And I suppose because we know that there's research, again, going back to some of to the Queen Mary survey and other surveys where the report is being that parties are getting frustrated with the time it takes and the cost of arbitration. And so Mark, for modern law jurisdictions, do you think that this would be a useful tool for them to also include in their laws?
Yes, I'd like to jump on that point and say I'd fully agree that this is a useful tool for them to adopt. Building on what you've said, when we look at some of the advantages of arbitration, we talk about the finality of the dispute and the speedy resolution of the dispute. And I believe this Section 7 of the 2025 Arbitration Act, English Arbitration Act, really introduces this avenue to speedily resolve disputes. Of course, as you said, you have to balance this against giving the parties a fair chance to present their case. But I do believe introducing this will sort of lean towards some of the positives within a speedy resolution of arbitral disputes. And when we look at the model law jurisdictions, obviously, the model law doesn't have an explicit provision allowing for the summary dismissal of claims. However, Article 19 allows parties to agree on the procedure to be followed. So, if the parties agree to the summary dismissal, then could it be included? And when we look at even the new arbitration acts, like a country that I know is specialty hard, Professor Onyema, if we look at Nigeria, for example, in the new 2024 Arbitration Act, they do allow for the parties or these rules to be applicable, whereby the parties can agree on the procedure or the process to be followed within the arbitral dispute itself. So it's a question of whether you can sneak that in this provision, but there's no direct provision allowing for this. So maybe if this were included, it would lend credence to the speedy resolution of the dispute. However, as we said, we still need to look at a fair hearing, which I know is in a number of constitutions, giving the parties a chance to be fairly heard.
Thank you very much for moving that. And Udayvir, please feel free to jump in on this, because the key question is, yes, the sections provide those expansive powers. But really, if you think about it as a disputing party, would you really want to agree, maybe when you have procedural order number 1 early on in the process, that, oh, okay, yeah, we're happy for you to summarily dismiss the application that we have brought if under this XYZ conditions? Most likely parties will not agree to that, but we don't know. But I think it's important that from what you have said, what it means is that there is possibility, if the parties want to do that, they can do that, but we're not sure if parties would want to do that for now. Udayvir, you're smiling. I don't know if Indian parties will be happy to go for summary dismissal. What do you think?
I think the parties in favor of whom the award goes will be happier as compared to but
which is true, yes.
Quite subjective.
Yeah, and then you start trying to set it aside, and due process questions will then be raised. Yeah. Okay, great. Tawan, did you want to pick up on something else? Is there anything else that you want to, any of the other reform matters that you want to pick up on before we move back to David?
One crucial point is, I think, is on the challenge of the jurisdiction, challenge arbitrator jurisdiction of Section 67. With this challenge, it is and it was based on lack of jurisdiction, which has always been a tricky area in the English arbitration, because when you got this balance between the tribunal independence and then the courts that they have the final says on the challenge. So under the principle of competence, the tribunal can decide on its own jurisdiction. But if a party disagrees, then it can still go to court and ask for the award to be set aside, even after the arbitrator has ruled. So that's exactly what happened in Dala v. Pakistan in 2010. The Supreme Court held that the parties could have a full hearing of the jurisdiction issue in court, including bringing new evidence and argument that weren't raised during the arbitration. Now, Section 11 of the English Arbitration 2025 tries to narrow that. It gives courts the power to limit what can be re-argued in courts, which are that it won't be allowed to bring new grounds unless you have shown that you haven't raised them earlier on the diligence, and that you can't bring new evidence unless it was impossible to present before the tribunal. And that last but not least, that the court doesn't have to rehear evidence that it was already heard by the tribunal. So what it does is that it prevents parties from using Section 67 as a second shot at the case, which in practice it caused delays, duplication, and then the extra cost that incurred on the parties. I believe it were in certain contexts it were used as a time strategy to negotiate during the parties. So critics have that some argue that the reform has gone too far, that it limits the court's roles, and that it puts too much faith in the tribunal decision. But personally, I think it's a fair middle ground, and that the courts still have final say. But just that at the moment, it encouraged that it respect the what the tribunal has already done, and intervene when there's a real prospect and reason to do so.
Yes. Thank you so very much. I think that is really helpful. What I put in the chat is a very interesting case called C&M Farming versus Peterson Farms. As a matter of fact, one of my PhD supervisors, Julian Liu, was an arbitrator in that case, and the award was challenged on the basis of jurisdiction, and the courts reheard the whole thing. And that just gives you a sense of how difficult this is and how costly it is. Going before the English courts is not a cheap a cheap process. And so, Tawan, it appears that you are happy with that reform, so that jurisdictional challenges will not be a rehearing of the whole dispute. Would that be a fair assessment? Are you happy with that?
Yeah, I think that's fair enough, because if you look at it, it allows you to go to the court, but not in certain circumstances that were heard before, that were not, you wouldn't be able to present new grounds, new evidence. Yeah. I think it's a fair, to some extent, fair between considering the point of view of the both parties, where in the certain case it has been used as a strategies, and then the costs are incurred. They use it as a means to negotiate, to cut a deal. So I think it's certainly fair to say.
Okay, great. Thank you, Mark. Any comments from the model law perspective?
Yes, just to say that I agree 100% with Tawan. I think the new English Arbitration Act narrows the grounds and promotes sort of the procedural finality. It's just interesting. So one of the key differences I noted between the model law and the English Arbitration Act is the English Arbitration Act still allows for appeals on a challenge. And it's interesting. I wonder why they never removed that section, but obviously by narrowing it down, it's understood that there'll be way fewer cases making it to court under Section 67 as it will be amended, and so possibly that's why they still left it. But in comparison with the model law and in relation to jurisdictional challenges, it obviously, the model law under Article 16.3 still allows for a full review, a full judicial review of the challenge of the arbitrator, the jurisdictional challenge of the arbitrator. And it's a fresh review, again, heard, as Prof said, in the C&M Farming v. Peterson v. Farms case. It brings about a full rehearing of everything that's going to happen. And when I look at Kenya, obviously where I come from, there's a number of cases that have been to the court on this matter where they've had to be reheard, and a specific case, Kenya Reinsurance Corporation Limited versus Road Traders MSA Corporation Limited, and another highlights exactly the issue brought about by allowing a full rehearing. So after the tribunal had made its ruling on the jurisdiction, this was challenged in court, and the other party then brought a preliminary objection to the challenge, arguing that there were certain aspects within the challenge that shouldn't be heard. And so the court had to go through the preliminary objection first, and then go through the challenge of the ruling of the arbitrator on their jurisdiction, and in the end actually overturned the decision of the arbitrator. So it shows that it shows that it can indeed bring about a lot of litigation and relitigation, which is what we want to avoid in arbitration, especially with costs and bringing about finality of the disputes. And so this is an aspect I'd really appreciate if the Central looked at it in order to sort of reform or reformulate this area within the model law.
Thank you. And that then means that a lot depends on who you appoint as your arbitrators. Because once the arbitrators have looked at it, so something like what we have under the Swiss rules and the Swiss law, then that's it. They've looked at it. And I think that's a fair way of going about it, because if we say that judges and arbitrators reasonably do the same things, then we need to be more careful. Parties need to be really careful on the people they appoint as arbitrators. Raoul, what do you think before Udayvir jumps on board? He's nodding, so which means he seems to agree. Raoul?
Yes, I would like to rely on a comment from a French academic, Professor Thomas Clay, who clearly invite French jurisdiction to follow that new provision. I was surprised because in the French Code of Civil Procedure, there is a disposition which clearly states that if a party will knowingly and without legitimate reason refrains from invoking an irregularity before the arbitral tribunal in a timely manner, shall be deemed to have waived its right to do so. But with regard to notwithstanding that provision, we had a case in 2020, case Schooner. It was an investment arbitration before the ICC, I think. And one of the parties didn't raise an irregularity before the arbitral tribunal and went before the Paris Court of Appeal to request or to set aside the arbitral award. And the Court of Appeal rejected that argument with regard to that provision. But before the French Court of Cassation, the court said that the party was allowed to raise that irregularity before the Court of Appeal, and the Court of Cassation annulled that Court of Appeal decision. So it was like a mess. We have a provision like this disposition from Chapter 69, which clearly said that parties have to raise any irregularity before the arbitral tribunal, and if they don't do so, they can be allowed to raise it before the judge of annulation. But in fact, it seems like there is a misunderstanding or some mess. That's why that professor said it is important to rely on the UK example.
Thank you very much. That raises really important questions because issues of waiver, most rules would, the UNCITRAL includes that, and the idea being that as a party, you need to be vigilant. You can't close your eyes to an obvious issue and hoping that if you lose, then there's something for you to hold on to challenge the award. And so again, which is why comparative discussions like this are quite helpful in helping us understand and conceptualize these issues. Udayvir, did you want to come on to this, or do you want to raise a new point of reform?
I think we've discussed this quite in a good way. I'm happy to move on to the immunity of arbitrators, which I think is a very important point as well.
Yes, that's absolutely fine. Please go on.
Sure. So, as per the new amendment, the new act itself, the immunity of the arbitrators has been elaborated, has been made wider in a lot of senses. And the issue which has been corrected is that although in the previous act under Section 9, there was a degree of immunity given to the arbitrators, but there was criticism that because the arbitrator immunity could be lost in certain cases, primarily regarding to where the arbitrator had resigned or if the party applied to the court to have arbitrator removed, in which case the arbitrator could incur liability for the cost of the application, even if it was unsuccessful. Now, to correct this, what the new enactment has made very explicitly as per Section 3, in very simply stating that arbitrators won't have to pay costs if they're removed by the court unless they act in bad faith, which has to be explicitly shown. Similarly, as per Section 4 of the new enactment, if an arbitrator resigns, they won't be liable for cost unless the resignation was, and that's the exact wording of the enactment, in all circumstances unreasonable. So as I show, it's not a blanket immunity, but immunity granted to arbitrators in cases unless there is a very apparent malfeasance on their part. So I think this is a very important amendment to give the arbitrators power, immunity, and peace of mind to rule as to give awards as per their own mind, and without a sword hanging over their heads in a matter of words.
Yeah, I agree. I think that clarification is helpful for arbitrators who worry. And it also clarifies the basis that an arbitrator cannot just resign.
Yes.
Because there is a consequence to that. If the parties have appointed and the arbitrator cannot for just about any, I don't feel like sitting as an arbitrator anymore over this dispute. No, the arbitrator should have considered this. And of course, then that leads us to engage with that question of whether the Reformed Act now recognizes arbitration as a profession. In other words, we need to take this seriously. You can't accept and then you just don't feel like it, or your friend has been harassed on the panel and you just resign. That's not a reason to resign. So I think it sits both ways, and that would be very useful. It provides clarity. So I do agree with you. I'm coming to Raoul. What do you think regarding immunity of arbitrators for the French law?
The fact is that in the French Code of Civil Procedure, we don't have any specific provision about immunity of arbitrators. So the response comes from national courts, from the jurisprudence, as we said. And the fact is that due to the dual nature of the mission of arbitrators, we have between contractual duties and jurisdictional purpose, it is difficult to say that arbitrators should not have any immunity. So the fact is that even though we don't have a specific provision relying on that immunity, in practice, there is like a partial immunity which is recognized to arbitrators. So when I read the English Arbitration Act, where we have specific provision and clear provision with regard to that immunity from arbitrators, I think there is something that the French code of the next French code of arbitration should rely on to draw inspiration to think about hard specific provision about immunity for arbitrators, because currently we don't have any specific provision and it's only relied on French national courts provision in the different decision they will take. So I think we might be inspired by that English Act in order to foresee some kind of provision in the French cause of arbitration.
Great, and thank you very much. And as you explained, it goes back to the way under French law, the practice or as arbitrator is seen. There's a contractual underpinning of that, which maybe that's the way to go as well. And going back to this whole concept and idea of professionalism, but because it's for a jurisdictional purpose or a judicial purpose, should some degree of immunity or protection be given to arbitrators? Mark, I was wondering if there's something from other law jurisdictions to also pick up on this point.
Yes, it's interesting. Again, another point within the model law that's not explicitly addressed and therefore governed more by legislative instruments in the respective jurisdictions. But when you look at these legislative instruments and you look at these model law jurisdictions, you tend to see the early adopters like Kenya and Zimbabwe and other early adopters don't tend to have any provisions relating at all to any sort of protection or immunity of arbitrators. Whereas the later adopters, you look at South Africa with their International Arbitration Act under Section 9, we look at Guyana under Section 63 of their 2024 Arbitration Act, even Nigeria as well under Section 13 of their 2024 Arbitration and Mediation Act. They all have provisions relating to immunity of arbitrators and protecting them in the event of anything. So I think this is a clear indication, maybe by the model law jurisdictions themselves, to sort of push the model law to consider, having this such that there's a unified sort of adoption by many more jurisdictions, which will then provide arbitrators with that much needed protection in the execution of their duties as arbitrators. So I think we're beginning to see newer adopters or those who are reformulating the Arbitration Act in the recent times are making changes or making this particular change within their national legislation, which is very interesting.
And maybe before I come to Tawan to see whether he wants to add to this point, before we pick up on our last point, the question then becomes whether this particular issue is also influenced by the common law, civil law divide, because for most of those common law jurisdictions under the common law, the arbitrator would have some form of immunity just because they perform a judicial function, and so maybe that is what is also influencing those common law, those model law jurisdictions in tweaking their laws. But Tawan, did you want to say something on this before we pick up on the last topic, which Udayvir would lead us on, which is on the disclosure? Yes. Did you want to come back on this point, please?
Just a little bit.
Yes, please.
Adding to this, I think a civil law system, which are mainly codified, protects to some extent the tribunal and the courts from subjected to being sued or certain decisions that were made. Yeah, I think that's all.
Okay, great. Thank you very much. So Udayvir, now the final topic is on the duty of disclosure, and that's the other. So we have Enka v. Chob, and then we have Enka and the other one, the case. What's the case called? Anyway, Udayvir.
Yeah, so I think what you're referring to is the Halliburton v. Chubb.
The Halliburton v. Chubb case. And sometimes in our heads, because they were about the same time, we missed them up. But anyway, please go on with the other Chubb case. So Halliburton v. Chubb. You were going to lead us on the duty of disclosure and the changes made.
Yeah, so again, comparing what was there before the 1996 enactment and what we have now, is that unlike the previous legal framework where the legal duty of disclosure was derived from a case law, the new provision offers greater clarity and legal certainty on uniformity, especially in the arbitration season in England and Wales. And what the Section 2 of the new enactment has done is introduce a new section, the 22A in the 1996 Act, which codifies the arbitrator's duty of disclosure for any circumstances that might reasonably give justification doubt to the individual's impartiality in relation to proceedings. Now, what is the most important part of this section is that it specifically says that the arbitrator must disclose not only what they know to be an issue, but what they ought to reasonably aware, addressing concern that some conflicts might remain undisclosed due to lack of due diligence. Now, these reforms clarify and strengthen the common law duty established, again, in the Halliburton v. Chubb, which ensures the arbitrator proactively disclose potential conflict of interest, because as per the previous act, it was a bit of a gray area. I mean, up to the disclosure of the arbitrator itself, and which left a lot of room for, case laws and issues. But I think this makes put some more responsibility on the arbitrators to again disclose not what they actually absolutely know to be an issue, but what might actually be itself. So it gives them a broader burden of responsibility, and to ensuring impartiality, which
Yes.
will again decrease the number of case laws going forward and in appeals.
So is that something you're happy with, that it's now codified in the law? At least that case was not as long as Enka v. Chubb. So are you happier with the codification now?
Absolutely, because I have personally dealt with that in our model case law in our arbitration class itself. Where it was a very big issue, because it was up to the interpretation of the arbitrator as to what they felt could if that was a problem or not. But with this new amendment, anything which might reasonably even they think there might be a problem, then they have to, in any case, be upfront with that. So I think this is great for arbitration in general in England and Wales, because this, I think, would give the parties a lot more confidence in the partiality and impartiality of the arbitrators. So I completely agree that this is a very good amendment to bringing more clarity and more
Yeah, great. Okay. Who am I turning to? I'm going to turn to Raoul. Duty of disclosure, French law.
Yes, honestly, when I read that provision in the English Act, I was really happy, because it was at least one point where both systems have common rules. But
so should we clap for both of them now that finally they have something in common? Please go on.
But in the meantime, there is something in the wording which differs, because in French law, when we talk about that duty of disclosure, we talk about impartiality and independence. But in the English Act, it is only impartiality. So instead of giving my point of view, I have also a question for you, because as you are an arbitrator, I know that if an award is rendered in UK and a party want to challenge it before French courts with regard to that independence, I don't know if from UK perspective there is a difference between independence and impartiality, because when I attended Professor Finizio class, he made that distinction between impartiality and independence based on objective or subjective factors. So I think there is like a nuance between both words. So what are the current purpose or the current outcomes of that difference in the wording?
Okay. And so it might be useful. So you're absolutely correct that even under the 1996 Act, the English Arbitration Act has never provided for both impartiality and independence. Lack of independence is actually quite clear. So if you just sort of think of having a financial interest in a company, for example, and that is very clear. The one that actually is very difficult is the impartiality, because that's an internal viewpoint, and how do you then assess that? And that's something that the common law via case law has developed, not only in arbitration, but over various aspects of English law where it is very clear, and the standard to apply is also clear under English law. So maybe that is why it had not been codified, or in the sense that there's a requirement for you to disclose. And now we have that, as Udayvir has clarified to us. Just sort of, as Udayvir was speaking, and Raoul, I was just sort of thinking, and Mark, it would be great if you can pick up on this, on whether this means that there will be greater opportunity to explore the IBA conflict guidelines and to use those as maybe to test and to just prep on what to disclose as an arbitrator under English, when you have an English arbitration. Mark.
Yeah, that's very interesting. Obviously, when you look at it from the model law perspective, and you look at quite a number of the model law jurisdictions, even in Africa, they tend to because obviously I should start off with, under the model law, it's much more general than it is in the new Arbitration Act. And so what the new Arbitration Act has made it more tighter and more concrete as to what to disclose. And so in that sense, from my opinion, it might not be as necessary in the English arbitration or under before the English courts as it would be before model law jurisdictions, just because it's much more general. So the IBA guidelines help to tighten it up and help to sort of nullify the deficiency, if I can put it that way, of the model law being so general in its wording of what to disclose. So in my view, I still think it's really good until obviously the model law or the jurisdictions themselves reword their provision on the disclosure requirements. But under the English arbitrations and under the English or the cases before the English court, I believe based on this new wording, it might not be as necessary to rely on those IBA guidelines. I don't know whether you're in agreement with that or whether
I think generally most arbitrators would use the IBA guidelines. I mean, we have clear case law from the English courts that say they are not bound by the IBA guidelines. And that, I think, a lot of jurisdictions, or some jurisdictions, especially again the common law world, will feel that way, because the IBA guidelines, they're just guidelines. That's what they are. But at least for those of us who sit as arbitrators, we would use those to enable us figure out what to disclose, because the guidelines are meant to be like standard practice that is generally accepted and understood within international arbitration community. So that people use the guidelines and look at it to help them figure out and decide whether there's a circumstance that they should be disclosing, whether it falls under the red, waivable, non-waivable, amber or green lists, to just sort of help calibrate the mind. But the way I was trained is, again, quoting Julian Liu, Julian would say, if in doubt, just disclose it. Because the tension is too much disclosure and under disclosing. So if it's one of those things that you can't sleep well at night, especially if you normally would sleep well at night, then just disclose it. And because, again, remember that just because you have disclosed it does not mean that the parties will say, oh, we don't want you as arbitrator. Yes, it's just they're informed, and they can make an informed choice on whether, oh, we're uncomfortable with this, or can you provide more information, or it's okay. The important point for the arbitrator is to make sure that the arbitrator discloses. But at the same time, the arbitrator, you should the arbitrator disclose, oh, I had lunch with David 10 times in 2025 or 2024, do you really need to disclose those sort of things? Maybe if you had lunch with Udayvir and Udayvir is counsel and Udayvir has appointed you, and in 1 year you had lunch with Udayvir 10 times, maybe that's a lot. Maybe that is something to disclose. Did you have lunch once when Udayvir came into town? Maybe, yes. You know, you met yourselves when you were in school in London, so there's nothing wrong with having lunch. Then should you disclose what the conversation was about when you had lunch? And if you had lunch 10 years ago, I cannot remember what we talked about over lunch. So it's you play it by the ear, which is why the IBA guidelines, I think they're quite useful to consult, to just sort of help with managing what to disclose. Okay. Tawan, did you want to come back on this? Yes, please.
Yep. Just a little bit of this. So when I think it depends on the topic of disclosing is to what extent the arbitrator have to disclose. Just I think quick question for our respected moderator. I think in some certain
I am moderator, not speaker, but go on.
but in some, I think in certain arbitrator where they themselves are also a consultant or working in a law firms. How would they balance out there? And when there's a high conflict of interest, of course, how would they balance out disclosing the disclosure and then the client confidentiality, the confidentiality of certain cases? How would they balance out for the arbitrator?
Yes, so the degree of what to disclose, which is why we all do conflict tests. And so by the time you do a conflict, you'd find out that for quite a lot of partners in various major law firms, they might not even be able to accept those appointments because maybe a subsidiary, they're already advising or they're doing something. So they don't need to disclose all the details, which will protect client confidentiality. And most rules will not require you to do that because you're already saying that, I'm sorry, there's a conflict of interest. I cannot accept the appointment. So one sentence should be fine. It is when you say that I'm happy to accept this appointment, but I may have a conflict that it becomes a little bit tricky because then you have to provide at least enough information to enable the parties make a determination on the point.
Yep.
Fantastic. So we've had a full hour of discussion which has flown by. Now you can all sort of breathe properly and relax. And thank you so very much. We actually covered much, much more than we had planned, and I'm very, very grateful for that. So we've had a couple of questions, and so we're open to discussion. If anybody has a question and they want to ask the question in person, just raise your hand. There's a raise your hand function somewhere up there on your screen or the bottom of your screen. If you click on that, I would ask you to please unmute yourself and speak. While the panel, if you look in the chat, there are a couple of questions. I think for the second question, the person can just read the English Arbitration Act and figure that out themselves. But you can look at the questions and see if there's anyone you want to answer. While the panelists are doing that, if anybody has a comment on anything that we've discussed, please feel free to also raise your hand and we would ask you to unmute and please speak. If not, if everybody is very happy and we hope that you're better informed and that we have achieved what we set out to do, which was a comparative discussion, so that on the various reforms contained within the English Arbitration Act. I'll be grateful if we can give a round of applause to our panelists. There's a virtual something, clapping of hands, or you switch on your camera and clap your hands or something. Thank you very much, David. Who again is clapping? That's me. Every other person, no, thank you very much. Every other person, you need to clap. Thank you. Thank you. We're very grateful for that. Okay. Do you guys want to pick up on any of the questions? Oh, Hossein, please. Thank you very much, Hossein. Were you planning to clap, or were you planning to raise your hand to speak?
Sorry, my bad. I was planning to good evening. My intention was to clap my hand, but I'm.
And your hand decided to raise itself. That's okay. Thank you so very much. That's very kind.
Thank you very much.
Thank you. Okay. Did you guys want to pick up on any of the questions, or do you think we've covered everything? Thank you, Simpson.
I could just quickly touch on Simpson's question. Hopefully I understood it correctly. I'm not sure about the English. I don't believe the English Arbitration Act, the 2025 Act, has addressed the execution of arbitration awards. But in a sense, and this was sort of maybe one of the recommendations I was thinking about in terms of a recommendation to central to the model law and to model law jurisdictions. And if we look at Germany, a model law jurisdiction that's coming up with their draft bill, which is being touted as very progressive, one of the amendments to the Arbitration Act as early adopters that they want to make is to have arbitral awards being issued as electronic documents, which I do believe would help in terms of execution of the award. And really progress and make it more of adopt modern strategies within arbitration. So to me, what Germany are doing with the Arbitration Act is very progressive, especially as it relates to technology and the use of technology in arbitration. And hopefully that's something the model law or Central can pick up on in future amendments to the model law for a wholesome adoption.
Great. And of course, there are various concerns with electronic, with electronic awards, even electronic signature. But you're absolutely right. We have to find a way round about that. And the issues around execution of the award go outside of the arbitration. And that would then depend on national law and the rules of court. And that goes also to Simpson's question. And as it relates to Hussein's question on what are the new grounds of appeal or challenging the award of, and there are no new grounds that are included, but the grounds that are there are already were streamlined. And that, again, the policy consideration being that we being England and Wales, want to be more pro-arbitration. We want more arbitrations coming here. We need your money. So come here to host your arbitrations. And the judges are fantastic. The courts are really very, very supportive. And there's a clear policy to support that. So back to our speakers. And so the Mark already picked up. So the last round of questions, since we don't have any comments or questions, is are there any other reforms that you think should have been included or that you would like to see included? And I'll start with Tawan.
Yeah, I think one of the keys issue that should have been reformed is the issue on confidentiality. That even though one of the main reasons that people choose arbitration is the implied partiality, it would be it would be very valuable if it's been in the statutory of the English Arbitration Act, and that even though it's treated as implied duty, it's been developed through case law, and that is not entirely consistent, especially when third party and then enforcement proceedings or public interest issue arise. A different jurisdiction like Singapore and New Zealand have codified the confidentiality for arbitration proceeding, with of course exception that are carved out and by the construe of the law that the limitation should be interpreted narrowly. This should work for all the parties. England should have followed suit, and that it should provide more certainty for user, ensuring the London as a seat for arbitration, for the global seat of arbitration. Yeah.
Okay, great. Thank you, Udayvir. So we have confidentiality. Is there something else that you think that they should have included?
Yeah, I think one of the things that the Law Commission recommended, which the new enactment didn't include, was a disclosure of third-party funding. Now, I think that is an aggressively growing field in international arbitration. And in my view, in principle, if it is if it's right, then there should be no issue disclosing a third-party funding in the first place. And if there is, if the parties feel that way, then that might actually be an issue, which all the more is the problem that needs to be disclosed in the first place. So, and if there is an investment of a third party in the arbitration, then they might not be involved directly, but that needs to be disclosed to the tribunal in the first place. I think that's a very important aspect which this enactment didn't pick up. I'm not sure if any other, I don't think any other jurisdiction already has this in place. I think in the next maybe 10, 20 years, we can actually see this coming up.
So the Nigeria Arbitration and Mediation Act actually expressly has that in.
Oh, okay.
I think maybe one of the reasons again is with the Packard decision impacting on third-party funding, and maybe the speed with which the arbitration reform has gone through while that of third-party funding is still waiting. That may change things. And a lot of rules now have it, arbitration rules anyway. The new suite of arbitration rules now include the need to disclose. Even ICSID now says
Yeah, ICC and ICSID guidelines, they do have it. Primarily jurisdiction like country-wise.
Yes, and so maybe the key thing, because it appears as though you think it's necessary, it's a good thing, then maybe that's something tribunals can pick up for now during the preliminary meeting and in their PO1 for the parties to voluntarily agree to disclose. Okay, great. Raoul and Mark. Raoul, then Mark. Anything, Raoul, is there something that you think French reform should definitely pick up on?
Yes, also, as I have already said, I think that it is important for French law in arbitration to draw inspiration for that immunity rules for arbitrators, because it is important to have clear rules which provide the framework for arbitrators to know which kind of immunity they can benefit from, because currently it is only relied on the national court's reason and means. So I think if we have, or if French law has to pick up something from the English Arbitration Act, it is clearly that provision related to arbitrators' immunity.
Thank you very much, Raoul. I'm very pleased that there's something the French can learn from the English. Mark, model law.
Yeah, model law. For me personally, again, touching on to what I said earlier, I think I'm leaning on a lot of what's coming into the German Arbitration Act as to what UNCINTRAL could maybe look into in any reformulation of the model law. The idea of technology and the impact of technology and bringing in provisions relating to the use of technology. But as you say, it's a very sticky area because it's really hard to regulate and with a lot of manipulation, and it's hard to regulate that manipulation and when you know it's manipulated and things of that nature. So it would be to touch on that with the moving times, and also something that's close to my heart in a sense is the allowing for anonymized arbitral awards to be released to the public, and especially within my research, looking at the court cases, and how they sort of interact with what transpired in the arbitration proceedings. It would be really interesting to also look at the arbitration proceedings themselves to sort of improve our knowledge on what transpires within the arbitration. So I think that's also an area maybe that UNCentral can look into, and look at how the Germans are doing it and maybe adopt a similar style to bring in more development of arbitration as a whole.
Okay, and maybe that's something they can do via their cloud, the case law on UNCentral texts, and to make available more arbitration related decisions. And maybe awards, anonymized awards, and also have those, because of course we have used Mundi, who are now making some of these things available. Great. So it's to say a huge thank you to our panelists. And just to sum up what I think that our panelists have engaged with. So our panelists have looked at the reforms under the English Arbitration Act, and they've sort of picked up on the 6 main items, the law applicable to the arbitration agreement, for which they seem to be happy collectively. That means they don't have to read 140 pages of judgment. So they're happy with that it brings greater clarity to this issue. Then they also then picked up on the new codification of the arbitrator's duty of disclosure. They're happy as well with that, even though Raoul still remains confused and not quite very happy with this whole idea of lack of impartiality and independence, lack of impartiality, but not including and independence. And so maybe that's something that we have to make a representation to the Law Commission so that they can be thinking about that. The panelists also picked up on immunity of arbitrators, and they all seem to be happy with the new provisions. And very importantly, Raoul is happy to recommend that to the French, for French reform, that they need to learn from the English, which is very rare. And so Raoul, thank you very much for that. And they also then picked up on questions around summary of the award and the challenge on jurisdiction, so Section 39 and Section 67 of the English Arbitration Act, and they're particularly agreeable to the summary award with the proper caveats in place to ensure due process, and they all seem to be happy with the Section 67 reforms. And then the other thing they picked up on was we've talked, I think that's it. Those are the 6 issues that they've talked upon. And things that they would have wanted to see were things around the duty of confidentiality. They've felt that should have been codified, disclosure of third-party funding, issues around technology, and going forward, the new developments in arbitration, which would include publication of anonymized awards, and the need, which goes back to transparency, and the need for access for academics and researchers and students. And so those are the things that the panelists have clarified. They have also they hope that the Law Commission will pick up at some point and do better reform, another reform project. If the French law, Raoul would send our regards and our views to them, and Mark will send our views and our regards to the model law people, the unsecure model law people. So thank you very, very much. We're very, very pleased and I am particularly very proud of the panel and the way you have prepared. Now they can relax. Before 6 p.m. today, they were under serious tension because they weren't sure how aggressive I was going to be with the questioning. But I really do hope you have all enjoyed it. Thank you to all those who have joined us. The recording of this will be on our YouTube channel. We do have a YouTube channel. Will be on our YouTube channel, and we will do a short summary as well and put on our LinkedIn page. Please, if you're not a member of the center, feel free to click on the link to the registration form and do join us, and so that you can receive our newsletter and you can participate in our events. Thank you very, very much. And this ends the webinar today.